Here.
Excellent. Okay. Fantastic. Okay, we'll make this quick. We have much to do today. Most of you know this drill, so I'll try to run through it quickly. Only ACUS members, whether or not on the committee, and their designated alternates have full speaking privileges, meaning that if you are not an ACUS member, you should write in the chat if you would like to speak. Please keep your microphone on mute and either use the hand raise feature or add a comment in the chat. If you'd like to speak, I'll call on you. You can unmute and then remute when you're done. I'd like to ask that ACUS members and their alternates use the webcam so we can see you. I think that helps the process. For attendees other than ACUS members and alternates, your participation requires the unanimous consent of the committee members. Time permitting, I will call on such attendees at appropriate points. We will presume that committee members consent absent raising an objection. If any such participant would like to speak again, please indicate in the chat feature or use the hand raise feature and wait to speak until I call on you. Unmute and remute when you are done. Please use the chat function only to indicate when you would like to speak. Please do not have any sidebar discussions. I know it's tempting, or put substantive comments in the chat feature. Only members of the adjudication committee may vote, and we will plan to vote today. Please do not vote unless you're a member of the committee. We have a list if you're not sure what your status is. Okay. Let us dive right in. I'd like to start with the preamble. Not the preamble, sorry. We have a preamble. I'd like to start with the recommendation. And we have all edits in here. Matt, we're good with that?
I removed I accepted any edits that we confirmed at the last meeting and removed the comments associated with them. What is left is edits that were submitted since then. And I have flagged areas that were where edits were not specifically suggested last time, but the Committee on Style was asked to revisit.
Okay. So we'll start at the top here. I think some of you will notice that there have been modifications to this section. It would be helpful to just we'll walk through each recommendation, and I'd like to hear from people. Let's start with recommendation 1. Anything here? I will identify, obviously, I think it's in recommendation 2. There is some discussion we should have on the use of frontline decision. If there's any indication that there's concern about that terminology or issues about how we should term that decision. It's obviously unique in a way to this area. We'll start with Michael.
Thanks, Nadine. So in the preamble, I added a paragraph to try to clear up a lot of terminology confusion at the previous meeting. In which, Nadine, can you back up to the paragraph in the preamble where these are defined?
Yeah, and we will take that up once we get to the preamble, but I understand you're trying to set the context here.
Yeah, so this language is new, and the idea is I was trying to generalize across the whole world of C adjudication with terminology that could be used consistently. So in this paragraph, the staff members make a frontline decision that the agency should impose a sanction or deny a benefit. Then there's
Another decision.
Yeah, so further down, so type C adjudication, the staff member who makes the frontline decision also makes the primary decision. And then the private party is entitled to seek reconsideration of the primary decision within the agency. So this, and I've tried to use that language consistently throughout. So that's the meaning of frontline decision. That's the investigation result when the staff decides, no, you're not going to get what you want, or you're in trouble. Then often it's the same staff member that makes the primary decision that says, no, you don't get the benefit, or yes, we're going to impose the sanction. And then typically there's a reconsideration by another staff member. So anyway, I just wanted to get that terminology out there.
Yeah, thank you. That's good background. So, and whatever changes we make in the recommendation, we'll obviously have to reconcile with the preamble terminology. Dan,
Sorry, I didn't have the benefit of the first meeting due to a scheduling conflict, but just on that language, Michael, which I thought was a really helpful addition. I guess the one thing when I read over that revision that remained a little bit unclear to me was whether the type C adjudication is what in that language is referred to as the primary decision or the reconsideration thereof. And I just feel like we should just state that because I think that at least led to some confusion on for me as to what to think of as the actual adjudication. Does that make sense, Michael? Oh,
Michael,
you're muted.
Yeah.
Sorry, the actual adjudication is the primary decision. So in other words, in the kind of a prototypical example, perhaps, of asking for a visa. You go to the consular office and a consular official investigates your application and says, no, that's the frontline decision. Then you have a chance to complain, to negotiate, and so on. And then the same consular official says, nope, you don't get the visa, Dan. And then there's a provision whereby you can get another official in the council to take a look at that decision. So those are the three steps. And I think the primary decision, that's the adjudication decision that we're really speaking about here. I hope that makes it clearer.
It does. And I could imagine us adding, even just for clarity, after the quote primary decision, we could even in parentheses add the type C adjudication of interest or something to that effect. And sorry, Nadine, if this is taking us away from recommendation 1, but I thought this was a helpful clarification for me.
No, I appreciate your weighing in on that. And it is something we're going to probably have to revisit, but we can put that in for now. So I have two more. Thank you, Dan. Let's go to Jack first and then Ken.
Great. Sorry, I'm in the courtyard at my school, about to go in after this comment, but that language struck me as odd, and it doesn't. I understand why it's precise, which I understand its value, and I was trying to think about. I don't have it in front of me, the APA, and there's things like proposed or recommended and initial decisions. And I would feel more comfortable with language like that, language that tracks the APA's provisions in that regard. And I think if the one that you call the primary, I would call the initial, because that's what you get appealed from. The one before that, I would call something like proposed or recommended decision. Maybe use that language all the time. Say that the first, instead of frontline decision, say the proposed or recommended decision, and then the initial decision is the one that you're calling the primary decision now. I think we ought to use language that's been previously used as much as possible, even though I understand the precision of this particular thing.
So Jack,
Anyway,
I tried all that language that's in the APA adjudication sections really doesn't fit C adjudication very well. Where you have the same person making an investigation. In other words, in ordinary type A adjudication, a staff member investigates and says, and then recommends some course of action, like this guy's in trouble or turn down the application. And that's a frontline decision. That's the one made by the investigative part of the agency. Then there's a separate proceeding involving an ALJ or an AJ or whatever, where you can participate, and that decision maker then decides the case. The ALJ decides the case, you lose. Then there can be a decision at the agency head level or an appellate body within the agency. But in C adjudication, the frontline decision and that first primary adjudication are combined, often in the same person or teams of people. So it's different. And I'm staying away, trying to stay away from the language of initial and recommended decisions and all that. It doesn't fit C adjudication very well.
I think I'll just chime in and then I'm going to turn to Kent and then Hi. Just briefly that I think it's very helpful to think about the steps that Michael's laying out. And I really think we're just focusing on terminology. And I understand Jack's inclination to use terminology that we're all comfortable with. But I also hear what Michael's saying. Ken.
Thank you. So I guess 2 points or 3 points. One, I really like this addition. I think it helps create clarity, and I really appreciate Michael's efforts with it. Second, I like Michael, I think I disagree with Jack because of what a proposed or recommended decision is. That is different than what we're calling a frontline decision. That is something that would happen later in the process. So I think we'd be creating more confusion by including that terminology. And then finally, I don't think I agree with Dan's suggestion on adding the type C adjudication, and I'm willing to hear that I'm not thinking about this the correct way, but I don't think the primary decision is in all cases the type C adjudication, because just as the rest of the paragraph indicates, you can have a primary decision from which one can seek review. And if we had later reviews, such as in the visa context, where we don't have an evidentiary hearing, but we have another step, well, that entire process is the type C adjudication, and that final step would give us the final decision of the type C adjudication. So I wouldn't define just one step in there as the type C adjudication.
Could I just respond to that directly, since I think that I don't actually, I was trying to hear Michael's answer as to what he thought was the type C adjudication. And that was exactly the question I had, whether it was the primary decision, the reconsideration thereof, or both jointly. I don't care which one we label. I just think we should be clear what we're referring to as the type C adjudication. Does that make sense, Ken?
Yes, it does. And again, Michael, he can correct both of us on this. My understanding is that the type C, the way it's being used, is the adjudication process for it. And there could be different decision points within that process.
Though the challenge then is that you would get the mixture, just as Michael said, of some things then become more formal and then are an ALJ type proceeding. And so that's why I thought, Michael, your initial answer was that it was the primary decision. But maybe, Michael, you should speak for yourself.
Yeah, I kind of agree with Kent here that the whole thing is the C adjudication that has a front line, a primary, and a reconsideration, which I think Jeff Lubber says should be called an agency review or something. But I think Kent's right that it's the whole thing is type C adjudication.
It's the process is the adjudication,
yes,
and there's steps in that process.
Correct.
Yeah. Hi.
My point was exactly the same, so I just want to add to why I think this paragraph works really well without it. It's type C adjudication differs from types A and types B in other fundamental ways, and then everything there was types A and B, how it works. And I'm staring at type C adjudication and I'm thinking, what am I missing? I now understand, Dan, what your question had been, but I absolutely think we don't put it there in the parenthetical where it was. So I'm simply, that's what I raised my hand for before Kent, you spoke. And I just wanted to reinforce that I think that's a good idea.
Anything further? Oh.
Sorry. No, I'm done.
No. I wasn't sure if Jack's point was to use, well, the first part of this paragraph before the shift in line 53 to type C is describing the typical type A and B adjudication, where that terminology is not necessarily the terminology, right? Jack, was that your point? I'll let Jack speak for himself.
I'm sorry, I'm just sort of trying to get myself settled in my office here, but I just don't, I have to just be frank and say, I just don't like that language. And I think part of it is because we're trying, it seems like it's an effort to put all these, we've talked about how varied they are, and now we're trying to put them all into a single mold. And we're making up new terminology, we're creating new terminology. And I just think, that, I mean, the way I think about it is that often the type C adjudications begin with an initial decision made by or a recommended decision made, with very little process. And then that decision after some input gets finalized, or gets memorialized. And then sort of what we would think of as the initial decision of the agency is the review by someone else or something like that. But I understand the reason for this terminology. It seems like when we're making a recommendation to a disparate agencies, to have to familiarize themselves with a bunch of like new terminology that's not completely intuitive what it means, I think it's just it's creating so that's my discomfort. But if everyone else is fine with this terminology, I'll just go along with it. I mean, that's just my feeling about it.
Is there any reaction to the use of the word decision in each step? I mean, obviously, in some ways it's an assessment, it's a preliminary view, it's a preliminary evaluation of an application. And as
the word determination, initial determination might fit somewhere. I don't know, but yeah, but whatever people come up with is going to be fine with me. Ultimately, I'm just trying to make it as,
I'll also
simple
just flag
as,
again that
coherent
in that initial part, we are talking about types A and B adjudication and using terminology that we then want to use in type C to describe type A and B. I wasn't sure if that's really the way we wanted to go. Michael, did you have a response to Jack?
Yeah, Jack, so last time this committee really ran into all kinds of trouble with inconsistent terminology, and I was really trying to create a single template in order to be able to phrase recommendations in a non-confusing way. You're right, I mean, there's a vast array of completely different kinds of proceedings swept under C adjudication. But I think the way that I stated it here is generalized enough to cover them all. And to make it possible to state recommendations that aren't totally confusing to people. Now, that was my effort.
Dan?
Sorry, this is mostly, so I'm still just trying to understand this distinction when you may have a primary decision where there's no sort of separation of functions, but then ultimately the reconsideration can lead to a more formal adjudication. And I guess okay.
Not typically, Dan. It's just somebody else takes a look. It's a second pair of eyes who says, yeah, the staff member got it right the first time. It isn't more formal. It isn't going into an evidentiary hearing. It ends with a second pair of eyes saying, yep, looks right.
Can we
that's
use
the key, is that the reconsideration does not ever involve a kind of more formal type process.
Correct. If it involves an evidentiary hearing, it's not C adjudication.
Right, because the way
that becomes B adjudication.
Okay, because the way this is written, at least to me, suggested that the linchpin here was whether the primary decision involved a staff member who what's the language here? Where there's just no separation of functions. It's the same person doing kind of the investigation and making the kind of primary decision. And that's at least the way the first paragraph is written. And there's no mention that it also excludes more formal sort of adjudicatory protections on the downstream reconsideration.
Right. So if that isn't clear, that's definitely the case. There's
no evidentiary hearing ever.
Yeah. There's just somebody else who looks at the primary decision. You get a second shot, but it's generally just as informal as the primary decision.
Can I make a recommendation that we table discussion of this paragraph, since we've kind of sorted through what we think of as the process, and we can go back to the recommendation and adjust this paragraph to the extent we think it needs further adjustment. I personally think that there's a little discomfort in the shift between explaining what type A and B is and then shifting to C, and we're using similar terminology. The type A and B adjudication speaks about a process that doesn't reflect my agency's process. So I had a little discomfort with that, but I realize it says typically, so it's not like a universal example of all type A and B adjudications. Obviously, our focus is type C. So if we could just shift back and think about, again, terminology now that we have some background that Michael's helpfully provided on the process, I think it would be helpful to just nail down if people are comfortable with the word frontline decision. Now that we kind of know what it's supposed to be doing, what's that terminology intended to reflect in the process? Or if there's another type of terminology we prefer to use there. Hearing nothing, we'll leave frontline for now. Okay. We have the same in 2. This is about allowing the parties enough time, giving notice to the parties so they have enough time to, I didn't know if contest was the right word. Maybe Michael can help me there. I guess.
Seems okay. That's the basic idea. Hey, that frontline decision is not correct.
And then submit evidence, and then the notice should provide information. And we have a list. Let's get some thoughts on the, do we have some language there from Russ? I'm not seeing the comment. Could you, Matt, could you, was that the terminology at 94, 95?
I was
This
just
is
agreeing with
Jeff's.
Jeff.
Okay,
I was agreeing
Okay.
with Jeff
I
Lovers.
see it now. Okay, great. Okay, any thoughts on 1 through 4 on the list as it appears on the screen? Okay. Kent.
Sorry, I can't help it. Maybe I'm misreading it, but number 4, does it say how to access to?
It does. Thank you.
Nadine, this is Anika. One quick thing on.
Hi, Anika. Yeah.
Hi, sorry I'm late, and so I
No.
apologize if someone has already mentioned this, but on number 1,
Mhm.
we use the word the staff's frontline decision, but then in other places we just talk about the frontline decision, and I wonder whether the word staff there is doing any work, whether we can just delete it.
We did not discuss that. Thank you for raising. I think that makes sense. Any thoughts on that? Okay. And I think, are we done with the list? Under 2, can move to 3. Hey, Russell's suggestion here.
It
Always
could be even
catch.
easier. Nadine, when I look at it again, if it just says should be in English and other languages, you can make it even simpler than my convoluted language
So such notice should be provided in English
and other languages.
and other languages.
You just don't want to say it the way it was written before it. Technically, it said it should not be in English. The bigger question is whether that same multi-language thing should apply to recommendations 6 and 8, and I guess we can get to that then.
Okay. Please remind us if we don't have a, thank you.
Eight and 16. Okay.
Hi, please.
Just a very quick question. If I'm an agency and I see it should be provided in English and other languages,
Mhm.
how am I supposed to think about? I mean, obviously it can't be in all other languages. To be honest, I have no word proposal to deal with it. You know, but conceptually, it's other languages that you as an agency know that these stakeholders, might be using. So I sort of, I don't have any word change that I would recommend, but I just sort of want us to be aware that if we just say English and other languages, literally has no limiting.
How
It
about
does-
widely used?
It
Other-
does say when
Yeah.
applicable and feasible. So, I mean, the opening language
Oh,
there.
I see. When applicable and
Mhm,
feasible, such
mhm.
notices to be provided in English and other.
So maybe the English part, I don't know. I mean, when would it not be applicable and feasible to provide it in English?
Then it's just saying such notice should be provided in other
Other
language
languages.
that affected stakeholders might use.
How
Or
about that? Let's try that.
Party might use, it's not that, or, okay, stakeholders might use. So take out the English, right? Because then you'll focus, when applicable and feasible, such notice should be provided in in languages that affected might use and be publicized to affected stakeholders other than the party,
Parties, right?
Then we probably should say that affected parties and stakeholders might use. Right, because then it just sounds like we're providing in English, because we made a distinction between affected stakeholders and parties. Parties might use and be publicized to effective stakeholders other than the parties. I see Russ had several other languages.
Any reactions there? Yeah,
I'm not sure what applicable is doing there. I think maybe it was about, is that about whether there's notices? I mean, I'm not, it says when feasible, I would say something like when feasible, such notice should be provided, in addition to English, such notice should be provided in languages necessary to ensure procedural fairness, to ensure fairness to the affected stakeholders, instead of languages they might use, because might use is pretty imprecise. Ensure effective, participation or something like that. I'm not sure exactly the language, but
my only reaction to that was whether, I mean, do we need to say that? I mean, obviously the notice, we've talked about what the notice is trying to accomplish above. And so it's really just that the vehicle, that information is provided be given in languages that the parties are using. Maybe, I mean, is it maybe when relevant? I mean, obviously, if it's relevant to the procedure, the process, that the applicant speaks only, Spanish, for instance.
Can you just say English and other major languages? Let it go with that. You're not going to cover all 100.
maybe just something like, instead of when applicable and feasible, just say such notice should be provided in languages that ensure procedural fairness or effective, I don't know, procedural fairness to affected stakeholders, period.
Well, I think then that's High's concern, that it's really about knowing what languages. Is it every language? Is it just major languages? I'm going to turn to Nina. She might have a solution for us.
Well, I don't know whether I have a solution, but I can certainly say, presidents have issued executive orders about multilingual initiatives, et cetera, for every federal agency. And then each agency should have some part of their organization that is identifying the top 5 languages. And these initiatives are throughout the federal government. And there are also tools, I can only speak for the IRS, but it has an
Mhm.
over-the-phone interpreter service that literally does have 150 languages and
Right.
sign language, you know. So
Right.
I think just saying, I think emphasizing the point about procedural fairness is really important. And then just saying in addition to English, and
Okay.
leave it with that. I don't know that we need to work the multilingual initiative in this paragraph.
There's some language that Matt just put up at the bottom there on 106, languages understood by people who frequently appear before the agency. We can think about that while we listen to Hai.
Yeah, so I actually think that in a way, although ensure procedural fairness would take a cover when applicable, I actually think I actually don't mind having a little duplication there. But we'll see. But when applicable, such notice should be provided in addition to English in languages that ensure procedural fairness to affected stakeholders. I think you can say and affected parties instead of and stakeholders may use. Okay, just an affected, take out the stakeholders might use, because again, I think procedural fairness, and Nina, this really reinforces your point. Procedural fairness means the agency has thought, who are the people who usually appear? Who would these parties be? So that's it. That's captured in procedural fairness. And I think that can be, agencies, I think, will get that. And of course, in the preamble, when you have the sentence about this, you say, look, right, agencies should try to ensure, obviously, procedural fairness. Part of that includes that you're putting notices in languages that you know parties who frequently appear before the agency will use, and like that. So I think the additional thing of languages understood by people who frequently appear for the agency is probably not necessary in the recommendation, because I think it's captured in procedural fairness.
Thank you. All right, we'll go to Jack and then Russell.
Okay, yeah, I'm looking, first of all, one of the things about this paragraph is number 3 has 2 different elements to it.
Concepts.
One element has to do with I think I was wondering why here. One element has to do with just getting the notice out to people, right? And then the other one has to do with the language thing. And I think that I just was looking quickly at, there's an executive order by President Clinton, 13166, and it refers to limited English proficiency. Maybe we ought to try to track language just saying that, be mindful of all requirements related to effective, what does it say here? It says to access to federally conducted and federally assisted programs for persons with limited English proficiency. Something like that. Use the language from the executive order. I mean, we'd have to track down whether that executive order is still in effect or if there's been something else, because
I think it is.
There also is some there's some there, I don't know if there's underlying legislation, but I think that's the way to go with this. And then the other part of it is just to make sure that notice is spread into the relevant community. So really direct language saying that such notice shall be widely available to the agency should ensure that such what did we say before? Agency should ensure that such notice is publicized to the relevant community, something like that.
Russell?
Language isn't going to ensure anything. Can you make it facilitate or try to ensure?
Yeah.
Up at second line.
Yeah, it's 103.
Yeah. Facilitate, promote.
All right, we have a lot of options here. let's go through, when feasible. I think we're keeping when feasible. That's what I know High has some concerns there, but let's stick with when feasible. Such notice should be provided in addition to English. I think that part is staying. In languages understood, or are we switching to this idea that agencies should be mindful of? You know, in providing these notices, agencies should be mindful of. So there's kind of two competing lines or concepts here. Matt, is there a way to break out the be mindful piece so that we can see it's on line 106? So when feasible, such notice should be provided in addition to English in languages that are understood by people who frequently appear before the agency. I'm not sure the be mindful language fits there. All right, Russell, I'm going to turn
Yes,
to you.
no. I don't have any more to say. I'm sorry.
Okay, all right. Sorry, your hand was still up. But I thought you had a brilliant thought. Hi, go.
So by the way, I never had an issue with when feasible, because that seemed to me good for the agency. It was just about applicable,
Mhm.
covered with procedural fairness. But once there is if there is an executive order in effect that actually places a requirement on agencies, I'm certainly hoping, but one should check that executive order, that it has some sort of feasibility built into it. But if it doesn't, we shouldn't be saying when feasible. I think if there is a requirement, that's what this recommendation should say, right? I don't know, but be mindful, but, you know, notices should be provided in a manner consistent with executive order, blah, blah.
Can we use agencies as instead of notices instead of the passive, is there any benefit to being active here and saying agencies should provide such notices?
Yes,
Consistent with EO related to effective access, just cut and paste that. And then I would be fine about also saying in the preamble, here are those requirements. And even if for some reason at some point that EO was rescinded, ACUS's recommendation is that agencies should still be complying with those concepts, because I'm assuming that EO must have worked through a lot of these issues.
Yeah, and I feel like we've said this before in another recommendation. Is Jeremy there? Does he recall this? I feel like we've covered this language proficiency issue in a prior recommendation, and maybe we should.
Must have.
Don't recall, but I can check.
Okay. All right, so let's go back to agencies should provide such notices. We've got should be provided.
Consistent with that. So you need to say though, add, you can, consistent with EO related to effective access to federally conducted and federally assisted programs for people with limited English. Oh, let's make sure that federally conducted includes government agencies. It has to, but you know what I mean? So, you know, people will get that when they see the recommendation, and then in the preamble, we can spell out, or at least let's send around to all of us, because it's not like we're going to meet again, but let's send around, okay, this is what the EO says, and therefore this is how we're describing it in the preamble, you know.
Matt and Jeremy, do you have any concerns with taking what we have so far, or do you want us to really try to hammer out some of this language? I think 5, what's number 5 right now at lines 112 is getting closer to where the committee wants to go.
I think it sounds like the committee basically agrees on the substance. It's just a matter
Yes.
of how to best phrase it. So I think we can take that consensus and try to translate it into language.
And then the EO can inform. I wish I could take the time to look. I swear we've covered this point in another recommendation. Jack,
Yeah, I'm going to put in the chat a page from the Civil Rights Division website about both the executive order and the guidance that was issued under it, which I think if we could just draw some really simple language out of that. And, you know, I know we normally don't like to tell people to follow the law, you know, because that should go without saying, but if something about guidance, you know, an executive order and a guidance, that's why I use the word mindful in this. And so mindful of, you know, the requirements of, I would actually reference the executive order if it's still in effect. I would say mindful of the requirements of Executive Order 13166 and relevant guidance pertaining to, and then use that effective access to federally conducted and federally assisted programs for people with limited English proficiency. And I would pair that with what you have in 3.1 and 2 right now, because it seems like otherwise it's redundant. So somehow put that together, what's in 3.1 and 2 and 5, what I just said in 5 together, or maybe what is in 3.1 and 2 don't need to even be there. I don't know. I mean, because the guidance, the order and the guidance really is directly on that. We don't need to reinvent the wheel on that set of requirements, I think.
I'll turn to Russell in a second, but I'll just say from my own experience that our agency has a limited English proficiency plan, an LEP plan, and most agencies have those. And it flows from that EO guidance that's come from that from DOJ. There's a lot of work being done in there. Some of it is bound by resources. I think Nina mentioned, you know, the translation services you can get over the phone. I know at our agency, we provide translation services to the extent that we have resources to do that. So I don't think this is a new concept, is all I'm saying. Russell.
Oh, just a minor thing on line 108, strike or try to ensure, promote procedural fairness. Yes.
Jeremy.
So are we really saying that basically the plans that agencies are required to develop under 13166 should actually, like, in formulating those plans, think about notices like this? I mean, maybe the emphasis is less on the notice and more in developing the LEP plan.
We're making sure the LEP plan covers.
Correct.
Right? Yeah.
Correct.
This sort of, I mean, the section here is about notice and making sure that the parties are given that opportunity. So I'm going to trust the Committee on Style to capture this before we spend the rest of our time trying to come up with language. Any final words before we move to, I don't even know what number we're at now. 6, it says.
Well, 3, 4, and 5 are all going to eventually become one number 3, but I just broke them out as we were discussing different options.
Yeah. Okay. All right. Opportunity to submit evidence and argument. 6. I'm not sure. I don't recall if this changed. I should be looking at my hard copy. But anything on 6?
I flagged any that changed significantly after the committee finished its deliberations last time.
Okay. Russell, did you have something?
I just asked the question of whether. Oh, I'm sorry. Never mind. I'm getting mixed up in my numbers here.
Yeah,
Sorry.
it's okay. It's actually 5 on the version I'm looking at my hard copy, but it's now 7. So credibility issues. I don't think we touched any of this. Am I recalling that right? Okay, so let's go to representation.
My point was, are 8, what's now 8 and 9, are those mutually exclusive? And if they can allow lawyers as well as friends, do those two merit combining? Eight says they should be able to have a representation by lawyers or knowledgeable layperson. 9 says they should allow participation by friends. Could those two recommendations be combined into one? I may be missing something here, but it just seems to me they don't need to be two separate.
Dan?
This is a separate point, but given the earlier confusion about whether we're referring to the primary decision or the reconsideration, I wasn't sure whether this language about representation refers to the reconsideration. For instance, if it's the primary decision, you have lots of agencies that conduct unannounced inspections. It would, providing kind of representation would imply a form of notice that would be infeasible for most inspected facilities. So I don't think this is really feasible for the primary decision, if it includes inspections.
I read this as covering the entire process again. Michael, do you have any thoughts to share on that this would cover?
Yeah, I mean, it would vary in the situation. Dan's right in pointing to inspections. Those are a very important category of C adjudication, like fish inspections. An inspector looks at your fish and says, "Ugh." But then you should have a chance to complain about his testing methodology and so on. So somewhere in there, you may need help in protesting against his testing methodology, and that's where representation comes in.
Right.
In other situations, they could be involved in the frontline decision as well. So I think it's stated in kind of a general way. Wherever it would help, you should be able to have a
At
right
any
to
step.
representation. Yeah, in any step.
I guess I find that a little challenging if EPA does an unannounced inspection where there's huge value in not giving notice to the party in advance, because
absolutely.
It does
you
not
don't get
make sense.
representation for an unannounced inspection, but you do when you complain about the results of the unannounced inspection.
Yeah, so I would like some language that's sort of about where appropriate, because otherwise somebody might read this and say this should apply. And, we really need notice to be able to hire a lawyer for any kind of for any EPA inspection, which means no unannounced inspections.
Yeah, that's right. That'd be fine.
We still have Russell's point that whether to combine the two recommendations. I'll turn to Nina.
This was a separate point, and I've been on so many program, calls that I may be mixing this up, but aren't we working on a series of recommendations about lay representatives appearing before agencies? So maybe we could cross-reference that somewhere if we're coming forward with recommendations about that.
Jeremy or Matt?
I think Nina's probably referencing the model rules of representative conduct that a working group at ACUS is currently drafting. I would probably recommend against cross-referencing to something that hasn't been published yet.
Okay.
Though obviously some of what we've been working on there has informed that line.
I also think we talked last meeting about not referencing the model rules to the extent that those are a formal procedure that implies type A or B and not C. Michael, is that?
Yeah, no, I think that's right.
Yeah.
Model rules just aren't about this kind of adjudication.
Not hearing any objection to Russell's thought, can I leave to the Committee on Style to combine those?
Do we necessarily want to combine them? If are we starting to muddle assistance with representation?
Yeah, as I understood it, representation was actually referring to someone who basically serves as counsel, whereas in 9, we're basically talking about if I'm appearing before an agency, I can bring a friend or family member to support me, not necessarily in a representational capacity.
Can we add some language to make that a bit more clear? So to provide support. Is it more about navigating the process than actually representing them? I mean, is there some language we can add there to make that distinction? Obviously, the section's about representation, so.
Dean, you could say, you could preface 9 with, apart from representation, comma, agency shall allow. Did that do it?
I think it does. I think it's helpful. Any reaction to that? Jeremy, does that speak to your point?
I think so.
Anything further here on new 8 and 9? I'm trying to see if we have other comments. We decided not to put, yeah. So that's Jeff's comment. Yeah, preamble. He says preamble, so we can leave that. Okay. Anything, oh wait, I'm sorry. Anything on 10? I'm not sure if we talked about anything. I want to open the floor for 10. Anything new 10? Plain language. Okay. Impartiality. We have
Do,
changes. Yeah,
I'm sorry.
Russell. No, go
Well,
ahead.
No, what used to be 8, do you want to engage all the stuff about other languages again?
Oh, 10.
8, and it also comes up in what used to be 16.
Think of,
Maybe
yep,
that
Matt.
horse has been beaten to death and we don't want to bring it up again, but I just raised the question. I think it's former 8. You know, reference to FAQs and things like that. That seems to
Like a
lend itself.
conforming, yeah. And, you know, I think your point is well taken that ensuring that the parties and the stakeholders are able to access these materials in the right languages flows through the whole process and not just then the notice section. So I think that's a fair point.
Okay.
Neutrality standards in 11. I don't think we touched that. 12, we've got the change from disqualification to recusal. Any reactions there?
I was thinking after the term financial interest, perhaps you could say financial interest or some other conflict of interest. Sometimes it isn't financial. Have a conflict. I'm not sure how to phrase it, but shouldn't be limited just to money things.
Anything else here on partiality?
Should we throw in a sort of consistent with government ethics rules or, regulations, or something to recognize that, like, there is some, there's a core foundation for these kinds of recusals and questions already?
Yes, from OGE.
Yeah.
Hi, on that point?
No, very minor point. So if you want to get closure on that, let's do that.
Might
I
be
think
best placed in a footnote.
Do we have footnotes and recommendations?
Do footnotes.
Oh,
Do
okay.
not.
Sorry, I withdraw.
No, that's okay. If I've learned one thing in all my years of doing this. I mean, we could, Anika, I don't know if you're still there, but, consistent with.
Yeah, that's what I was thinking at the beginning of this sentence, consistent with government ethics
Requirements, or, yeah.
requirements, exactly.
We used to have David Apel here. I don't know if he's still a member, but he used to keep us on our toes in that area. And I don't, is it necessarily agency regulations? Obviously, maybe it's just agencies, or if there's already.
I mean, I guess
authority.
I would think that, like, we would want there to be some clarity about how
Mhm.
agencies are going to make those kinds of decisions. So like, we have in our agency, both supplemental ethics regulations, and we
Okay.
also have certain other recusal regulations, if someone has done something else in a case, like been a mediator or something like that. And so we do put that in regs so that, parties can have confidence in like who is actually deciding their case.
But they're supplemental. I remember this from a prior recommendation where there was concern about agencies needing to flow those regulations through OGE.
Yeah, that was me too, because we we had to go through that process. So
Yeah.
and it's a lot.
And to the extent we are maybe overlaying formality here that we might not want to in the type C situation. I think this works if you're comfortable with that. Mika. Okay, hi.
Yeah, this is a small thing, but I was reading and I'm not sure what the word particular in front of matters does. Another financial other conflict of interest in matters they are investigating or deciding. I mean, obviously it's going to be a particular matter if they are investigating or deciding. But
That's
maybe
right.
whoever put it in, there might be a reason that I'm not catching.
We should also look at the last sentence there to the extent that line 137 now says agency should require. Do we need to couch that second sentence in terms of agencies that have special government ethics regulations? Should tailor them to, I don't know, or do we not need that line any longer?
That line's. I think you don't need it, and you definitely don't want regulations there.
Okay. Any other thoughts here? We also have regulations in 13. New 13. But I'm not sure that OGE covers that situation. Hi.
Even if OG doesn't cover it, I still think we want to say especially, well, that agencies should require recusal
Mhm.
unless the agency decide whether it's in a regulation or something else.
Okay.
And I don't know if it's, if one also needs to say the consistent with, because I just don't know the substance of that enough.
So let's take out regulations there and just say agencies should. That's what you're proposing, hi? Yeah. Yeah. Anything further on 13 or 14? Okay. Statement of reasons, and we got an orphan heading there, but statement of reasons has one recommendation. Anything here?
Didn't we have something about telling people about the decision above? I'm sorry, I didn't raise my hand, but didn't we have that? No, that's where we did all that language thing?
That was on notice of the decision, not the decision itself, if I'm recalling.
Oh, because it was noticed that that's the decision that would be coming in case they wanted to contest it. Okay, and
Right.
this is,
Does this
but-
need to
Well,
move up?
yeah, I think maybe we should add the word yeah, exactly, the word primary there.
yeah. And we just want to conform it to, again, whatever we've said above about the various languages, because obviously you want the rationale and reasons for the primary decision to follow the So just not here, but just a note to conform it.
Jack,
Yeah, I think I would, I would put statements of reasons in line 148. If provide oral or written statements of reasons, and then I would shorten up the ending of the provision to say rationale for the primary decision, including the factual and other bases for it.
anything else? Hi.
Yeah, just this question, just read it, then I like that, Jack, but then it should provide oral or written statement of reasons setting forth the rationale for the primary decision. So the statement of reasons presumably is the rationale. So isn't it? No, I was saying rationale is duplicative. Shall provide oral or written statements of reasons for the primary decision. Okay, do you think reasons setting forth the rationale, you don't mind that duplication?
Yeah,
They either it's the statement of reasons for the final, for the whatever primary, whatever we're calling it. Now, let's just keep setting forth the rationale for the whatever we're calling it. Yeah. I mean, it's a little duplicative. I think people can see that, but I think here duplication is actually fine. It's reasons setting forth the rationale. Fine. Fine.
okay, let's move to administrative review. I think we left this as is from last time. Procedural regulations. So this was where Matt had a concern. I don't know if he's still on. I know he said he was going in and out, and I don't remember if we covered this last time. Maybe Matt G, not Matt W, can keep me honest here.
Matt Weiner is not currently on the line. I believe we skipped Matt Weiner's comments last time because he was also out.
Okay, well, Matt has a concern that I've seen in prior recommendations, and I agree with that. Notice and comment is great to use if you have the ability and resources to do it in situations where it's not required. And so I think that was his concern, is acknowledging that. Hi.
I just want to strongly endorse that. Dealing with an agency now where I'm trying to do a ton of stuff with policies, just so I'm not dealing with obviously policies that we can legitimately do as sub-regulatory. So I just want to the extent we have language that makes it clear that there is some sort of cost benefit, and so long as you can have a document that carries the weight, right?
So I think there's some good language in the comment there. I don't know if you can see Matt's comment. It's that last line of the quote, thus unless the costs outweigh the benefits, we strongly encourage agencies voluntarily to use it even where an exemption applies. I don't know if there's language we can pull from that. Matt's right on it. Matt G. Anything on that? Does that, I guess we'll hear from Matt Weiner if it doesn't. I think that, Heidi, what do you think of that?
Yeah, I think that's right. Should voluntary use for the adoption of significant procedural regulations. So we have the thing about significant, even though notwithstanding the APA section. Yeah, unless the positive.
Well, I think Matt's point, though, is now that you're saying significant, that okay, I think we're okay. Jack.
I just want to know, do we want to reference this recommendation 92.1? And so instead of saying notwithstanding section 553BA, just say consistent with ACUS recommendation 92-1, agencies should voluntarily use notice and comment rule, and then, and get rid of the notwithstanding. Is that better?
I like it.
Any reaction? Jeremy, Matt, no, okay, good.
Well, then, and maybe you could get rid of the language about costs outweighing the benefits, since that's discussed in greater detail in 92-1.
If I may, my inclination is to maybe put the phrase "unless the costs outweigh the benefits" after 92-1 to make it clear that that's coming from that.
I like that.
Okay.
I hear what you're saying, Nina, and I agree with you. I'd like to think that the agencies who get this will read that recommendation, but I'm going to look at high here and say for implementation purposes, I think it's better to expressly say what they would find if they were to look there.
Right. I like the placement where it is. Yeah.
I like the placement, but it's not, it makes it sound as if with the unless that somehow cost outweighing the benefit is different than the recommendation, right? With ACUS, unless the costs outweigh. So it's more consistent with ACUS recommendation 92-1. Actually, I think it's confusing. I think, either something like consistent with the ACUS recommendation, which analyzes, costs outweighing the benefits, but I almost think it's better to just with ACUS recommendation 92.1, agencies should do that. And that's a good thing in the preamble to say, this is, then we have a few sentences that we can explain ACUS recommendation 92.1. And in the, as you know, my big believer in the 2-pager, right, that would go with this, you're going to have some bullets and that's where you would just say it, clearly. Because I do like referencing that ACUS recommendation and piggybacking on all the work that went into that.
Can we pull up that is the comment gone? I was just going to look at that language again that Matt had quoted. Yeah. Okay. Okay. All right, let's move on. I think 18 was the one that Russell had flagged again. Matt has identified plain English. Again, I think we have the point about language here. Hi.
This is clearly just something that got left off. We no longer want unless the costs outweigh the benefits. It just didn't get deleted. Yeah, just we have that covered with consistent. Thanks.
No, I think we were thinking we wanted to retain that. Jack, no, did somebody? No, am I the only one that wanted to retain that? So that it's clear to the agencies that they don't have to go look at the recommendation. They know exactly.
Well, and that's what I thought, and I'll let Nina speak for herself too, but it seemed to me that was, if we're going to put a should like that, we should have the qualification that comes out of the recommendation also.
Right.
I take it back. I take it back. That's right. Recommendation said voluntary use for the adoption of significant procedural regulations.
Unless.
Yeah, I know, but if you look at his comment, it's more that he just said the general thing is you look at costs outweighing the benefits, and then he just says, or the recommendation said, for significant procedural rule changes, the benefits seem likely to outweigh the costs. Well, you know what? I guess let it be at the moment, and maybe this is just making sure someone looking at the line. We're all agreed on the point here, so let's just make sure that since people don't know what ACUS recommendation 92-1 will be, you know, I almost sort of feel like you are probably better off saying not doing the consistent in the recommendation, but just in the preamble, and just say here, agency regs specify the procedural details. Agencies should voluntarily use notice and comment ruling for the adoption of significant procedural regulations unless the costs of doing so outweigh the benefits.
So are you suggesting to move the language high, or you're just,
don't, whatever you're doing is don't do that.
yeah, I think we'll keep it at the end.
At the
Yeah.
end, no, keep it at the end.
Yeah.
What I'm saying is if you put it at the end, I don't think I would put consistent with ACUS recommendation 92-1 in the recommendation itself. I think it's good to put it in the preamble to explain this sentence, because this sentence captures, right, based on Matt's description of it. Oh, no, look, you guys, it's not good. I mean, if the recommendation says that even for significant procedural regulations, you can choose not to use notice and comment unless the costs outweigh the benefits. You are having the word significant procedural regulations. I'm almost thinking that your best way of doing it is back to the way it was before without repeating unless the costs outweigh the benefits. And then you're just back to saying whatever we said, consistent with that recommendation, voluntarily use notice and comments, and do not have unless because that is then confusing. Wait, unless the costs outweigh the benefits for a significant procedural reg, you know.
Can I jump in? I'm sorry.
Sure.
I think that when Matt says in his comment, no exception is made for significant regulations, what he means is that the cost benefit analysis qualification applies to significant regulations and any other regulations. So that, therefore, I think it's just reinforcing what's in the content of 92.1. I think it would be a little bit misleading to leave that out, because as we've been saying, it's unlikely that the people's first reaction when reading this is to go, okay, I better go to the library and look at recommendation 92.1. And the recommendation, really, the main points of it are voluntarily use it even if there's an exception, unless the costs outweigh the benefits. And so I think it's better to put it right in there so that it doesn't get dismissed as, you know, unreasonable or infeasible, or, you know, or something like that. So that people can be still following our recommendation, even if they end up in a certain circumstance deciding not to do notice and comment because it's just too costly based on the benefits. And of course, these matters are likely, since they're type, you know, C adjudications, they're not likely to be that's, you know, on the significant side, not as likely to be on the significant side of the line as when we were having a formal adjudication.
Yeah, I withdraw the recommendation. I'm cool.
Anything further here? I'm sure if we don't have this correct, Matt W, probably Matt G too, both Matts will keep us honest on this. Okay, and then we have the comment here for 18 about plain English, which I think we had, and I'm losing track of my new numbers now. I think this is the 3-point that Russell was flagging in terms of plain language, other languages. We want to reconcile those. I'm starting to wonder do we need to repeat it in each section, or do we need a standalone one that just covers the entire process? I'll just throw that out there for committee on style, that we can make clear that guidance documents, notices, decisions, every aspect of this process should be done plain language and offered in other languages. Hi.
I realize looking at this, I have a question about other languages for staff manuals.
Oh, I see what you're saying. Yeah.
I mean, so definitely all of these things should follow federal plain language guidelines. But, you know, the other languages, certainly the notices, maybe the FAQs. So I just wonder if we can,
Yeah, staff may, I think the other documents, guidance documents, procedural instructions and FAQs that are gonna be on the website versus you're talking internal staff manuals. Is that what you're thinking?
sometimes staff manuals are put on a website as well, but I just sort of feel like it's really important to say that staff manuals should be in plain language. I just don't know about the burden on the agencies to have the staff manuals in the other languages. I mean, even if it might be put on, I don't know. I feel like the executive order must have dealt with these issues, like it must have said which types of documents.
So we have documents on our website that are instructions, guidance documents, FAQs in Spanish. We've only got one language. We don't, but we have the services or the abilities to translate in other languages. Staff manuals we don't put on our website. I'm just talking about my own agency.
Yeah.
So I think you raised a good point.
It says are easily accessible. So we're talking about those. So maybe we just say should ensure their guidance documents, procedural instructions, and FAQs are user-friendly. And a staff manual is sort of a guidance. So if an agency does that, hopefully it'll just be included instead of guidance documents. Otherwise, I think we'll get a reaction because then it's
So-
actually the staff manuals should be easily accessible. And
Are you proposing we take out staff manuals?
that's my proposal. We
Okay.
just put that staff
Great.
manuals, and I think we don't have the problem.
Jeremy,
Yeah, Nadine, I think Matt's question was whether regulations should be included in this list of documents, less about the other languages point and more. This says that agencies should ensure guidance documents, manuals, procedural instructions, and FAQ should be available. What about regulations? Should they be written in plain English and available on the website?
maybe that should be first on the list because it flows from 17. I hear what you're saying. Thank you, Jeremy.
That totally
Totally.
Yep.
Nina?
I'm gonna go back to the staff manuals. I personally think staff manuals should be user-friendly. If the user is the staff, it should be user-friendly.
Sure
and-
hope so.
And I also would say, you know, eFOIA, they're accessible, you know, they can be recused if, you know, they can be redacted based on, you know, exceptions and exclusions from eFOIA, but eFOIA says put them on the website. So, you know, for example, the IRS has thousands of pages of its Internal Revenue Manual on its website and searchable. It's not necessarily in plain language, but it is able to be searched. And it relates to procedural, you know, how these procedures are going to be done by the employees. And you can see what the employees are supposed to do. And when they're not doing them, you as a participant in the procedures can say, why are you not doing this? You're supposed to do this.
Thank you. Hi.
So I completely endorse what Nina just said completely. And I think if we just have the sentence the way it is right now, nothing about that comment under Matthew's COS to confirm with other languages terminology, we should have the regulations, guidance documents, staff manuals, procedural instructions, FAQ. They should all be user-friendly, follow federal plain language, and be easily accessible.
Yeah.
Once we want to put something in about other languages, don't think we want the regulations, and I don't think we want
I
necessarily.
agree.
So let's just think about that, and maybe it goes back to your point, Nadine, of instead of repeating, maybe we have an overall piece that says if you're dealing with notices, rationales, FAQs, you know, guidance documents, then whatever language the staff comes up with to conform to the EO and make sense.
Yep. Yeah, and I don't know where that fits. We'll have to look and see where that might work. Maybe it's at the very end. I'm not sure that there's a heading that suits it, but will the Committee on Style figure that out? Jeremy's nodding, thank you. All right, we want to shift to ombuds. We have 2 sections left in the recommendation. I want to watch our time here. We broke this out. We had discussed this last time, so this is broken out in the sense that if you have an ombuds program, we want to make sure that they're empowered to handle these complaints that might come in on type C. If you don't have an ombuds program, but you have certain circumstances such as a significant caseload or high stakes, the recommendation is telling agencies to establish one. And then we have the carve out that if you have a smaller caseload, lower stakes, maybe you share an ombuds program rather than standing one up. And then the last recommendation, which I think Russell has suggested revising, which I think is a good revision, is if you don't stand one up and you don't share one, there should be some mechanism that you use to receive feedback and complaints. Okay, Dan.
Just for consistency with recommendation 2016-5, I think we should, in the new paragraph 20, line 168, change the language to should consider establishing such a program. That's at least the way I read 2016-5, which is the first recommendation, says agencies should consider creating additional ombuds offices.
I think we discussed this last time in terms of the preference for should in these situations. Is anybody, I know the chair has some thoughts on this front and whether consider establishing works here. I have not looked at that recommendation, so I would assume, Dan, you're probably more familiar with it than I am at this point. And if that's consistent, then we want to be consistent. Hi.
So yeah, so I mean, I looked at, that pages 64 to 65 in the report and all, and I think that what we discussed last time makes sense to me, which is these are adjudications that are not evidentiary. So that is different. And so I'm fine about saying that as a recommendation, they should establish such a program. And I'm pretty sure, and I don't remember the 26-5, and again, Dan, you would know it better, that obviously was for everything in the agency. So I sort of like they should establish such a program. That's our optimal thing. But those that choose not to establish or share, because then it said significant caseloads or significant stakes. Because remember we said ACUS has type C, they choose one contract over another. Well, they're not going to fall under 20. That's not necessarily significant caseload or significant stakes, right? And we did say it would be good if ACUS had like one person who was designated to receive an email about it. So I really like how this is written. But I do think it makes sense to say should establish in these type C adjudications.
Agencies that face sufficient caseloads, I mean, it's still within the agency's expertise to determine, is this a sufficient caseload and a significant stake such that we should establish one? Jack.
Yeah, I'm torn about this because I think, I think we discussed this
We did.
before, and I'm just not, I'm not so sure that we want to tell all agencies to follow a single model on this. There may be agencies that, wouldn't have sufficient work for an ombuds person, or, the formalities that come with that. And so I think I would leave it as it is, except I would suggest one change, which is in line 175. Instead of less formal procedures, I would say alternative procedures. Whether they're formal or informal, I think we're agnostic on.
Mm-hmm.
Or indifferent to, or whatever. That's the way I feel about it. But
Nina.
Yeah, I'm looking at the recommendation and it, just in number 1, establishment and standards, the very first paragraph says agencies should consider creating additional ombuds offices to provide places, blah, 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 blah. And, the legislative recommendations are Congress should consider. So, the should consider language is throughout the recommendation.
Which is what Dan said. Mhm.
So I think that's consent. This is from someone who believes profoundly in the ombuds office. So
Thank you, Nina. Very helpful. Hi.
So just to pick up, Jack, as you said, so we discussed this at some length in the first meeting. We did not come to a conclusion. We said, let's go back and mull. And Michael, you might want to weigh in again here. One of the things you said, yes, you did think there should be an obligation, not obligation, but you do think there should be an expectation, unlike 2016-5, that absolutely did say you should just consider. And I'm also a proponent of them, but I also would think generally it should just be consider. But the question to us as a committee is, are type C adjudications different enough that even an agency that, after considering whether to have a general ombuds program, decided not to, that we're saying here, you've chosen not to have a general ombuds program, but you have a sufficient caseload in these type C adjudications, or there are significant stakes. Okay, what we're saying is you should establish such a program. Okay, just sort of, Nadine, as you said, you as the agency decide whether you have sufficient caseloads or significant stakes. You should establish such a program. And then if you do, hey, check out 2016-5 because we provide best practices for the establishment of standards. And then I think we give enough flexibility to agencies in 22. Agencies that choose not to establish, we're not writing legislation. They don't have to agree with our assessment. But we did leave it at the last meeting as, what does this committee think as a sort of policy matter? Because it is an issue not covered by that 2016. And where I ended up, after looking at some of this stuff, is where I'm at in terms of saying should establish. Which, Jack, it seemed to me you said you were fine with everything and just wanted to change, which I agree, alternative, but I could be wrong on that.
Yeah, I was fine with everything.
We do have a should consider in 21. Just note that. Hi. You're muted.
Sorry, I'm trying to be good about that. Exactly. What we're saying in 20 is, if you've got a sufficient caseload, if you've got significant stakes, you should establish such a program. Now, if you have smaller caseloads, you have lower stakes, you have lack of available staff, you should consider sharing it with other similarly situated agencies. Or, so I think a lot of agencies might not want to do that, or go to 22. Just provide alternative procedures. I mean, this seems like a nice whatever sequence of
flow to capture each possible scenario. I agree.
Thank you.
Yeah.
But I think it should establish for.
Okay.
Maybe need to take a vote. I don't know.
Yeah, Kent, let's get.
I just wanted to quickly echo that I may have been the stronger proponent against saying that agencies needed to have an ombuds person established anytime they had a type C adjudication, but I'm extremely comfortable with this essentially kind of laddered system of thinking through the ombuds program. And I agree, if you have significant caseloads or significant stakes involved, you should consider having an ombuds for it. So I really appreciate this resolution.
Yeah, I just want to be clear that the last, just to give background, at our last meeting, I believe the recommendation was just should establish an ombuds program without any qualifications about the circumstances under which that might be appropriate. So this, I love the ladder concept, Kent, that's very helpful. This laddering concept of where you might fall and what you should do, was what we came up with. Dan.
I guess let me spell out kind of my thinking of why I find it, I'm more comfortable with the consider language. It's both a consistency with the earlier ACUS recommendation, but as Nina pointed out helpfully, that recommendation has both Congress and the agency as an actor, and the creation of an ombuds office to run effectively would require resources. And here the recommendation is agency facing. An agency should consider establishing, and maybe this is just my recent experiences of the number of agencies that have had what they perceive unfunded mandates of create this office, do this, and the concerns about resourcing behind that. And so that's why I think the consideration to me here is really the strikes that right trade-off. I just don't, I'm thinking of the huge range of type C adjudications here. If you had an ombudsperson just for EPA inspections, EPA has a bunch of different ombuds offices for different sort of vehicles. Given the sheer volume, that could be a really significant task. So that's kind of my perspective of why I would favor being consistent with the 2016-5 recommendation.
Thank you, Dan. That's very thoughtful. Appreciate that. Nina.
So maybe there are two categories here. There's one where we say should consider where it's sufficient caseloads or significant stakes, should consider, but maybe should establish where the participants are likely unrepresented, because that is where the ombuds really goes into, ensuring that procedural fairness that might otherwise not exist in some of these type C hearings. I don't know how you would phrase that. I'm just saying.
Are you thinking that would be another, so with sufficient caseloads, comma, significant stakes, comma, or unrepresented?
Consider establishing such a program, and then maybe where there is where the participants, where a significant number of participants are pro se, the agency should establish such a program.
But regardless of whether you have a sufficient caseload or significant stakes, so even if you have low stakes and a low caseload,
No,
as long as you have, as long as you have a number of pro se parties, regardless of your caseload or your stakes, you should have a program. Is that what it would say?
That's hard I'm trying to think through that. I was kind of thinking it was a subset of sufficient caseloads or significant stakes. Because
So
again,
that's why would we add it to the list? So an agency that's not got an ombuds program, but has a high caseload, has significant stakes, and a number of pro se parties should establish.
right.
So why could we build that into the list of? Does that make sense?
Me, it does.
No, I was thinking, Matt, I'll try to be a little more clear here. So agencies without an ombuds program, but with sufficient caseloads, comma, significant stakes, comma, and or, I don't know if we do and or, pro se parties should establish the program.
Well, I was actually trying to address Dan's point by saying if you had sufficient caseloads or significant stakes, you should consider, but where you have pro se parties, you should do it.
Regardless of your caseload or stakes.
Yeah,
Hi.
Nina, I thought that's a really interesting idea, but what I just heard you say is as a subset. So what I was
I'm going back and forth. I'm trying to,
well, yeah. Well, I will tell you what worked for me, and again, hearing the concerns about should versus should consider. I really like the sort of compromise, which is, I think I could handle, right, agencies without an ombuds program, but with sufficient caseloads or significant stakes in their adjudicative programs should consider establishing such a program.
Right.
Okay, that's sentence
Right.
number. So just take out the or, take out the pro se, but add should consider establishing. Okay, so let's all see that. Okay, that's just should consider. And then it's a new sentence that says, let's just do it repetitively for the moment, and then you can work with the style. So just kind of paste agencies that are ombuds, but with sufficient caseloads or significant stakes. Okay, so just cut it and paste that again. Okay, that comma, end with, not but end with significant numbers of pro se parties, right? Should establish such a program. Okay, that makes it very clear that we're saying, we think you should consider establishing. We're not going to say should. We did all that in 2016-5. I will have to say, for anything about an unfunded mandate, like I said, this is no control. This is not any mandate, what ACUS, much as we feel we want to have some impact, it's only not a mandate, but and with significant pro se parties should establish such a program. You probably need I don't know if you need a comma after parties. And then here's our recommendation with the best practices. I think that's a nice compromise.
Dan?
I too like this compromise. The only thing I'm thinking through is what it means to be a pro se party, given that these involve inspections, campsite applications, and the like. So maybe we should think of some language that would refer to individuals who can't even through the reconsideration process secure a form of representation. I don't know what
concern about, if I may speak, that my concern about, tagging it onto the review, reconsideration process is that the pro se parties often fall out at each level of, administrative review, given that just because it's an increased administrative burden on them. And you want to try to get the right answer at the first level.
Jeremy?
Yeah, I hate this phrase, but Dan, are you trying to get the idea of sort of legally unsophisticated parties, whether or not they have access to counsel? These are people that are not closely regulated entities. They don't know the program inside and out. So
yeah, I too think we need to finesse that language. We can put
right. I hate that language, but we're getting this idea of
but that's the spirit, right? It's like it's
right.
Pro se is like different in like an inspection context,
right?
And a campsite application.
Yeah,
We can use committee on style for that possibly. But let's just be sure we're comfortable with the concept here. So we're sticking with should consider for the first category, but should for agencies that are in the first category, but also have the legally unsophisticated parties. What's the likelihood that you have a sufficient caseload and significant stakes and you don't have a large number of? And what is a significant number? I mean, I don't know. I'm just trying to determine what the real distinction is we're making between the should consider and what actually we want you to do. We want you to just think about it versus we want you to do it. Hi.
Yeah, I think it's problematic. They'd be like, what are you talking about? And again, I'm not sure that committee on style is gonna it's going to be a little tough, right, to do that. So maybe even though I was sort of strong on the should establish, I think maybe the better way is to, because of the concerns that have been raised, should go with should consider establishing, I mean, this isn't legislation, so it's not hugely important that we don't say should establish. And we just make the case, this is again an implementation. We just want to make sure that our staff, others have the resources, really, partly because of what, Michael, you did in your report, have the resources to make the case. So maybe I think, even though I was strong in it before, I would be fine about saying should consider establishing and not, I think the compromise, much as I liked it, actually, it can cause other complications.
And we had some differing thoughts on this. It would be helpful to hear if anybody wants to go back to should. Dan is happy. You started this, Dan. I hope you're happy. I know Kent had a reaction. Do you want to weigh in further? I'm not pressuring anybody to say one way or the other. Nina?
I just want to be clear that if we're going back to should consider, we are including language in there about programs that have significant numbers of, whether you're calling them pro se or legally unsophisticated participants, that's in that list, and you are
Okay.
in that list.
I'll just throw out this thought again, Committee on Style. Agencies without an ombuds program should consider establishing one, particularly when they have sufficient caseloads, significant stakes, pro se parties. Not
Right.
pro se, we're not going to use that word anymore.
Language, or whatever language.
I'm sorry. Did you get that? Particularly if they're type C adjudication system program has, something to that effect. And whatever pro se legally, whatever terminology we want to use, we can leave that to Committee on Style, I think.
Right.
How about just unrepresented parties?
I think we're concerned about using that terminology, given that this might cover more than just those aspects where you might need representation. Dan, I see you nodding.
Yeah, that's right. I think, Jeff, the idea is that because this includes things like inspections, the ordinary kind of EPA inspection, there's not really such a kind of concept of having a representative around. That's sort of why, at least I was a little bit uncomfortable with the earlier pro se language.
What's a legally unsophisticated party?
That was just our placeholder. I don't know if you just joined us.
I did. Yeah. Okay.
Committee on Styles. We had pro se there initially, but decided that was not going to work either. Any thoughts on this language or what we could use to help Committee on Style there? Okay, we're going to move on. So this is our ladder. Any further thoughts on the ladder here? We have from 21 to 22. I don't know if we need any conforming edits. I don't think we do. We have should consider in 21. And we have the language in 22, which I think works well. Any other thoughts before we get to the final recommendation? Jeff, you're right on time for the final recommendation. You have a comment, which maybe was that from last time? I think that might be Jeff's comment from last time.
It was Jeff's comment from last time. He was not present, I believe, when we covered.
When we covered it, okay. Well, let's turn to 23. Any thoughts here? And Jeff, if you want to weigh in, you have the floor.
I just thought it was a preambular statement rather than a recommendation, but it's more a style question.
Any reactions here? I know there's a lot there to read through. Don't think we touched this otherwise, Matt. Last time, yeah. So we do have the reference above to the ombuds recommendation. So I don't know, maybe it doesn't stand out as much since we referenced the ombuds recommendation in
Yeah.
20.
I don't feel strongly about it, but I know there's been a effort to avoid
Pushback. Yep.
statements like this.
Okay. All right, hearing no reactions. We will leave it for now. Okay, I think we're done with the recommendation. Matt, am I crazy? I think we are. So we should go to the preamble. I think Jeff's comment there, we took out that last line. Is there any reaction to that?
In the footnote.
Yeah, in the footnote. I apologize. Yes. Okay, and then we have Matt Wiener's comment about legally required. Do we need to add language there? Is that what he's proposing? Sorry. So I think, yeah, Matt's suggestion is he suggesting we add language, or I know he's not on the call? Any thoughts? Hi.
Unless I'm missing something from Matt, I'm not sure why we would need to explicate that.
Okay.
Then I feel, and each time it's legally required. It might be from a reg or a statute or an EO. I mean, it might even, be from a policy that's, no. No.
You would think we should keep it as
Yeah,
is.
legally required. No, he said, should the first sentence note that legally required means legally required by statute, regulation, or executive order. That might lay, and I'm saying, why would you further explicate? Isn't that what he's saying? Should the first
Yeah,
sentence?
I think he's looking at 11 and 12 where we do explicate.
Oh, I see. In many federal, over no constitutional provision, statute, exec grants parties the right.
I mean, I'm tempted to just say there are no legal requirements for.
We don't need to say it twice.
Right, yeah.
Oh, I see. We don't have to do it twice. Okay, then you can take it out. Many adjudications include an opportunity for an evidentiary hearing, sometimes because it's legally required, sometimes not. That is a proceeding in which they do. Okay, type A, this is F type B, this is right, because this is preamble. In many federal, however, there are no constitutional statute. Okay, that works. Sorry, I wasn't.
Okay. Anything further in this first paragraph? Here's Matt's, Jeremy, sorry.
Just a note on legally required. So the earlier recommendation, 2016-4 on type B, defines type A and type B versus type C as things in which there is a legally required opportunity for evidentiary hearing. It defines legally required to be statute, regulation, or EO. So that's where that comes from. I mean, mostly just to make sure that's consistent, like that this how this relates to 2016-4. I mean, that's why legally required is here.
Okay, well, since I was the one that raised, I'm not sure why, that explains the why, in which case, and of course, usually if Matt W says something that we should pay attention. So that's what you're saying. Maybe many adjudications include a legal requirement under a statute, regulation, or executive order, a legal requirement under a statute, regulation, or executive.
That's covered in the next paragraph, though. So I think
what Matt is saying is just introduce it here, and then at
Yeah.
12, you would just say,
introduce it generally here with legally required, and then in the next paragraph, spell it out.
Yeah, I think he would flip it. Matt would do the specificity first and then go
Correct.
general.
No, I don't think he wanted to do that. I think he was just,
Can we pull a comment up again just to be sure? I actually read it as he wanted to say it in both places. The specificity.
I think that's kind of overly wordy, though. I mean,
I don't disagree.
legally required introduces the concept, and then in the next paragraph,
Then it explicates later.
spell it
Yeah.
out. But he questions whether we should even mention constitutional provision because we haven't mentioned it in previous recommendations.
Yeah.
I vote for leaving it as it is, legally required up there. And
And
then,
then,
you know, he has two other points. One is he wants to add something where footnote 2 is, and then maybe take out the words constitutional provision.
mhm. Any thoughts on that? Leaving line 2 as is, revising 11 and 12 just to take out constitutional provision.
That's where I had started.
Okay.
I think constitutional provision should be mentioned. There are situations in which due process requires an evidentiary hearing, no matter whether anything else does. So
just because we didn't mention it-
I think it's appropriate to mention constitutional provision. Now, whether you want to put it in line 2 or line 11 is, I don't care.
So Matt's comment, are we seeing the full comment? I'm not sure. Does it say as a source of the legal requirement, maybe? I don't know. Maybe it's cut off. No, the third comment. There it is.
So Michael would have argued that it should have been in 2016-4, but
Right.
we didn't put it in there. So
Right.
We did not.
I'm not sure it's a big problem if we put it in now.
Any reaction to my friends at ACUS, Jeremy or Matt? Do you have a thought on this in terms of consistency? Committee, take it out, leave it in. I think we're set on 2. Let's leave 2 as is. And then the explication, do we want to include constitutional provision? Any objections to that?
Michael thinks it's appropriate. I'd leave it in.
I think it is.
Okay, moving on. There's Matt's comment on footnote 2 about the exclusive record principle. He wants it in the body. Any reaction?
There's an easy way to draft it into the body. I'd put it in, but I'm not sure there is.
I think you just pull up the point. That whole line.
Yeah.
You could either, yeah, which means that, yeah. Yeah. And then the footnote could move to the end there with the site. Do you still need the site? Yeah. Yeah. Hi.
Okay, so I think that's fine to move it into the text, because this is where we're describing this, but if you move it into the text, okay, good, you just left it to super note 1 at 10.
Yep, yep, we're good. Okay. So now we have, oh, okay, all right, so we did, can we just go back up, Matt, really quickly? We're done with 14 through 20. Anything on 14, lines 14 through 20? Next paragraph. 21 through 27. And we have legally required there, which I think works. Talk about stakes. Okay, anything? All right, we're going to jump to the paragraph that we worked on a little bit at the beginning of the meeting, and let's be sure that we're all still comfortable with it as it stands now. We have something from Jack. Did I miss that? Wait, starting on line 24.
This is an earlier paragraph, not the paragraph that Michael added.
Okay. So did I miss it?
Where are we? What did I click on?
The paragraph starting on line 24, I suggest switching the order. And I'm not sure which paragraph.
That's reflected now in the way it is.
Okay,
My
Great.
concern was that we said what it isn't first and we said what it is later.
okay,
And it looks like it's been fixed. If that's okay,
Excellent.
if that reads well.
that's, I'm happy to hear it's fixed. Wonderful. Thanks, Jack. Okay. Anything further in this section? This is where we have,
Could you roll the document back up to the previous paragraph? Where did we lose my attempt to establish common terminology here?
oh no, I thought it was this paragraph. No, we didn't. It's further down, right, Matt?
Okay.
That's the next paragraph. This was
Yeah,
a
sorry.
paragraph where we talked about the characteristics of type C adjudication, and Jack Bierman had requested that we flip it to prioritize characteristics that are of type C, and then put other characteristics lower in the paragraph. Russell Wheeler agreed and made some other changes.
Hi.
So I think this is great. I really like those recommendations. Based on that, assuming none of us disagree, can you just go ahead and accept?
So we
those
can read it.
changes? And I'll see it, because then I have a truly small thing, but
No, I think,
just accept, and then you'll see. Let him just accept, and then. Okay. So based on this, my one thing is where your cursor is right now in front of agencies, I would make that a new paragraph. Okay. So, okay, it involved this, ex parte is routine, they're free. Now, agencies that engage typically employ, there's no reason other than ease of reading for the reader, but. And I clearly do not feel strongly about it.
any reactions? Okay, let's move to the next. Do we have anything outstanding? I don't think we do. We got Jack, let's resolve that. We got Russell, let's resolve that. We took care of that. Yep, we did. This was my, yeah, okay, we're good. Matt, this sentence should be more specific. Don't know what that means. But maybe. We don't have any language from him there, so.
I'm questioning the last sentence. In many cases, such as those involving inspections or sanctions, the party may receive. I mean, I think that sentence is extraneous.
This sentence was inserted before Michael inserted his paragraph, so the paragraph might say in more detail what this sentence was trying to say concisely.
I think that's the one that Matt was referring to too, so
Yeah,
he didn't
just,
he didn't like it.
just delete it, not necessary.
So we have a one sentence paragraph, if everybody's okay with that. I know some people have reactions to that.
Oh,
I don't.
But you know what? Given that you have one sentence, I'm fine with the reader. You can go back to. That's fine. It was just, there was so long.
So much, yeah.
I
Well,
withdraw
maybe that,
the previous request and go back to making that the last sentence. That works for me. Okay.
okay, now, sorry, I had thought the prior paragraph, this is the paragraph that was added that we talked about at the top and wanted to be sure that the language here is consistent with what we're agreeing should be the terminology for the initial, I think, assessment, what's called here as a frontline decision, and then the primary decision.
So,
And yeah, go ahead, Michael, if you want to.
Well, I don't know. I think this paragraph should go ahead of the previous one. I mean, I was really intending this to be really fundamental in the analysis, and everything flows from that.
Can we scroll back up to see what leads into this? I'm not sure I'm getting the context here.
Right. So I put that paragraph, yeah, the way you have it now at 28, and I don't think you need the word other.
Yeah, I don't think you can use other now.
I mean, this is the basic idea, the whole foundation of this thing.
Okay. Okay, Jeff doesn't like types A and B.
Well, that's
Oh,
We
no, I
can
don't-
fix that one.
It wasn't that. It was that I didn't like types A and B.
Yeah, that's what I said, types A and B in line 29
Oh, yeah.
it's also there as well.
Just take out the S. I also don't like attorneys general, but that's different.
Do we need to adjust 29 then? Because it also says types A and B.
Just take out the S, yeah. I think it's, well,
So I just want to, again, I want to flag that that line from 29 to 31 is not at all consistent with how my agency is structured, which is split enforcement. Now, I just point that out. I realize we're unique. There's not many of us. So my agency does not do the investigation. It's done by a separate agency.
Right.
And
So I think that's a really good point.
so typically, I mean, we have typically there, and maybe that's the shelter we're looking for to make sure that we're not saying that this is how it is in all type A and B
I'd
adjudications.
say often rather than typically. Because this is a little different from the way Social Security operates too. There's an intervening reconsideration between the front line and then the ALJ.
Yeah, the frontline decision is made by a different agency. In the case of tribunals like OSHRIC and the mine safety, it doesn't change the analysis, but it's maybe we can adjust the language to say that the frontline decision could be by one agency and the neutral decision maker could be another agency.
But even in Social Security, the Disability Determination Service is a contractor, state contractor. It's not the same agency.
That's true. So
This-
that's right.
this
So that's not uncommon.
This paragraph's doing a lot of work trying to trying to summarize everything here. Pretty hard.
Well, I mean, there is, rather than try to explain what a type A and type B adjudication is, you could leave that first sentence and point to a
Yeah,
report.
I think it's actually okay as it is now. It doesn't say that the frontline decision has to be made by the same agency that provides the neutral decision.
Do you have some thoughts here?
Yeah, I have a few. Number one, for ease of looking at this, since I think we all agree at the moment that it's useful to have a paragraph like this, I would just accept this change. So we're just looking at black type, and then it'll be easier for us. Second thing, I mean, this is back to Michael's point. I think for folks reading this, they're not gonna necessarily remember type A, type B. I think it's very helpful to put in some of these, this type of paragraph. I quite understand Jack's point, I'm sorry, about new language, but I think it might be helpful. So I would do something like this in 29. In type A and type B adjudication, maybe you can just say an agency staff member, because it's an agency staff member, often conducts an investigation of possible sanctions against a private party or determines whether to grant an application from a private party for benefit or licenses, okay? For this recommendation, we call this a frontline decision.
No, oh, okay, but this is type A and B, not C.
So go back. The staff members then make a frontline, I'm sorry.
No, this is something that I flagged earlier, the frontline decision is being used here to describe a type A and B adjudication.
Right, that then is a problem.
That's right.
That's a problem. So because we want to use that, we want to explain how we're using frontline, primary, sometimes reconsideration all together in type C as opposed to. So why? So is it not a, maybe you remind me about the term that is used for decision. I mean, it's not a recommendation, it is a decision, right? So is it the staff members then decide whether the agency should impose a sanction or deny a benefit? Right, isn't that?
The frontline decision is that the staff wants, if nothing else happens, the staff decision is going to be final, that the benefit is denied or the sanction will be imposed. But that's the frontline decision. It's trying to say that this is the frontline decision is separate from the primary decision in type A and B adjudication. That's the point I'm trying to make here. Now, the A and B's, in some cases, they're done by separate agencies, but it's still a separate thing. The frontline decision, there has to be one, right? Something has to set this in motion. And then there's a separated decision, evidentiary hearing, and decision by a neutral decision maker. But these two things are combined in many type C adjudications.
Right. But in order to
that's really the point, the essential point I'm trying to get across.
Then I would recommend that instead of saying, then make a frontline decision and introduce that there in type A and type B, it's better up to say because the previous sentence is type A and type B, and that's why it's a little confusing, right? Would it serve your purpose to then say the staff members then decide whether the agency should impose a sanction, right? They decide. And if the private party does not acquiesce, then you go to an evidentiary hearing.
Well, I'm really anxious to use the term frontline decision here.
But that's for type C, not for type A and B.
No, it's tough. Type A and B have frontline decisions too. They all have frontline decisions.
Okay.
The essential difference is that it's combined in a type C adjudication with a primary decision, but in type A and B, it's separated. but it's, for this analysis to make any sense, you have to say that A and B agencies do have frontline decisions. And then they have a separate evidentiary hearing.
Okay.
That, I mean, I think you need to do that for this to make any sense.
I'm gonna flip it to Jeremy quickly if he has a thought here.
Sure. So I think there's a couple of points going on. I think, Jeff, you raised a good point, which is that type A and B agencies are wildly different in how they structure this. Nadine, you have a split enforcement agency. At SSA, state agencies acting under contract with a federal agency do this. At CMS, it's private sector contractors. What if we say something like, in type A and type B adjudication, a frontline decision maker typically conducts an investigation of possible sanctions. If the private party does not acquiesce in the frontline decision, it is entitled to an evidentiary hearing before an ALJ or AJ.
I think that's great. That's perfect.
Yay.
I like that.
I think, Matt, we already have, oh, that's fine. If the private party does not acquiesce, is it 30, 34 and 35? So I think you could delete. Yeah. Yep.
Okay, but you still have something wrong on 30. A frontline, you might want to have a dash there. Frontline decision maker typically conducts an investigation, possibly sanctions.
Yeah, sorry, I cut out what I didn't read the whole sentence, but it would say conducts an investigation of possible. You can just leave in what it was before.
Yeah, it's exactly. I knew that.
Possible sanctions or denial of a benefit.
Yep.
And then get rid of lines 32 to 33 halfway.
And then say if the private party does not acquiesce in the frontline decision, which works in that phrase.
That's perfect.
And okay, I was just going to suggest not say might be called, but we have a couple folks here who want to on 35. Jack and then Kent.
I'm having
Jack?
real trouble with how this is structured because it said the first sentence starts out, it differs in fundamental ways. They differ in fundamental ways, and then it just describes each of the things instead of a paragraph being written about how they differ. So, I mean, in other words, so I would say I've been starting to try to write it on my own here while I've been listening, and so I would say type C adjudications differ from. Let me just read this out before you start typing because I want to see what people think of the concept. Type C adjudication differs from type A and type B adjudication in fundamental ways. Then I would say in all types of adjudication, an agency staff member may conduct an investigation of possible sanctions against a private party or determines whether to grant an application for a private party for a benefit, license, or the like. And I want to add the like because there could be a permit or some other thing. We're like, and determines whether to impose the sanctions or grant the application. In type A and B adjudications, the appeal from this decision is before a neutral decision maker, while in type A and B adjudications, typically an appeal from this decision lies with a neutral decision maker, while in type C adjudications, the frontline decision maker also makes the primary decision, something like that. I mean, I think we need to, the thing should be structured to contrast the two rather than just state what each one is. To make the contrasts explicit, because the paragraph is about how they differ. So I could try to write this whole paragraph up and send it along, but I need a little more time. But that's the way because they both have in common, correct me if I'm wrong, Michael, they both have in common that all three have in common that there's an initial person, you call the frontline decision maker, who investigates and decides whether to impose a sanction or grant the permit or benefit or license or whatever. Then in type A and B adjudications, there's an appeal to a neutral decision maker, while in type C, any reconsideration, the first level of reconsideration is back to the initial person, right? And then,
well, I don't know, Jeff. I think
isn't that what you're saying here? And then you say the initial staff member in type C adjudication, the staff member makes the frontline decision, often also makes the primary decision. So what you're saying is,
you know, you could add the words in contrast or something like that, but I think the way you're, changing it makes it harder to follow. I mean, I'm trying to
but
draw
am I correct that in A,
the
B,
clear
and C,
contrast, but it's a matter of style. I won't speak further to this.
am I correct that in A, B, and C, the second sentence applies?
Yeah, sure.
Yeah, so that's why I would not say in type A and B, because it leads the reader to think that there's going to be something different in this regard with regard to type C, but it's not. It's the same.
Well, it's
In all
several sentences. Type you have
no,
the
it's just
front
that
line
one
decision,
sentence.
and then you have the
And then the next sentence.
evidentiary hearing before a neutral decision maker.
So here's my suggestion to keep this paragraph as close as possible. How about in all three types of, yeah, exactly. In all adjudications, the front line in types A and B, if the primary is not acquiesced, yeah, that's exactly what I'm trying to say. Whereas by contrast, in type C, the staff member makes the frontline decision, often also makes the primary decision. Okay, that's better.
Ken,
Thank you. So I think my concern takes off from where Jack left off, and it really goes back to one of his earlier points. And I'm always worried about being a little too pedantic with this, but I want to make sure what we're saying is accurate and not creating more vagueness with the terms we're introducing. So when we begin with that sentence in type A and type B adjudication, if the private party does not acquiesce in the frontline decision, it is entitled to an evidentiary hearing before a neutral decision maker. I think everything there is correct. The decision of the neutral decision maker might be called the agency's, and I recognize this is in quotation marks, primary decision. Well, maybe. It depends what it is, for instance, the ALJ is deciding. It could be merely a recommended decision. It could be a tentative decision. It could be an initial decision. It could be a final decision. But if it's merely a recommended decision, I wouldn't call that the primary decision, because there hasn't actually been a decision by the agency yet. And the reason I don't think this is too pedantic to get into is I think this is going to matter more and more as the Supreme Court is deciding who is an officer, and a final officer versus, I'm sorry, not a final officer, a principal officer versus an, what's the other one? I just went blank. Final and
Inferior.
Thank you. Inferior officer and principal officer. I think it's going to matter more who actually has the formal power of issuing the order. So I'm trying to figure out from that sentence whether we really need to get into this primary decision terminology at all, or we could just get rid of the decision of the neutral decision maker. Do we need that sentence?
I think I need it. A lot of the recommendations below, distinguish between frontline and primary decision. I mean, I think Ken's making a good point, though, and possibly could be covered in a footnote. That the primary decision might, in some cases, be a recommended decision that the agency gives. That's still not. I mean, that might become more common, but it's still rather atypical now.
Not just recommended, but initial. I mean, and we are introducing a new term that's not really used very often in administrative law: primary decision.
Mhm.
I kind of agree with Kent's concern.
Well, I needed it. I mean, for the
it might be called a primary decision, but
I think I have less concern using it in the type C context, but I have more concern using it, especially with type A, where we have defined terms in section 556 and 557 as to what the nature of potential decisions are. And even in the next sentence saying that there is review, quote unquote, of the decision. Well, that's not true with a recommended decision. That would be the decision of whether to adopt the recommendation or not. It's not reviewing a decision.
It's a good point. I think could be covered in a footnote. That particular
Jeremy.
variation.
Oh, sorry. Where do we use the term primary decision anywhere in the recommendations? I mean, the point here is to introduce a term that we're going to and explain what it means to use it elsewhere, but where do we actually use it?
There in 15, yeah, you know, where the statement of reasons is for the primary decision.
Yeah.
So maybe in those cases, we think whether that's the right term. I mean,
Mhm.
there's no need to address primary decision, what the primary decision is in type A and type B, right? All we need to say is there's an evidentiary hearing before somebody, the end. We don't need to get
Well, it's nice to be able to say, in contrast, the front line and the primary decisions are often combined in the same person. But to say that, I first had to explain the primary decision in types A and B. I mean, I'm just trying to make this one, you know, it oversimplifies a lot, but it gets us across. At the last meeting of this committee, there was all kinds of difficulty with terminology and what's the administrative review? Well, what's that of exactly? And is there an initial and then a final? And it became very confusing. And I think that was a very serious objection to the whole thing. So I was trying to really clean that up and provide a very general template to contrast A and B on the one hand and C on the other. And I needed some word like primary decision that is broad enough to cover both what occurs in type A and B and in type C. So, you know, maybe I didn't succeed, but I felt I needed that terminology, and I didn't want to borrow 556, 557 terminology, but to state it in such a general way that it would cover all kinds.
Can we just use some general term like in type C, further proceedings take place before the same person? I mean, not those words exactly, but something like that without trying to define a new term of art?
Well, up to you guys. I like the term of art because it can stretch nicely to cover all kinds of adjudication.
Hi. And then I'm just going to flag, I need to step away for 1 minute and I will be right back. But hi, please speak and continue the discussion.
Okay, and then that's good. Then I need to step away. So I totally get sort of, you know, the various concerns here. I have to say at bottom, I am more convinced by Michael because if we're going to be wanting to talk to agencies about these differences, maybe that is when you need to come up with a new term. I mean, I sort of like, and I think Michael, you did too, just calling it a frontline decision maker typically conducts an investigation. But then, you know, still then calling it this frontline decision, does not acquiesce in the frontline decision. So I guess, you know, it's almost like a cost benefit analysis. There are some costs to using a new term, and it's good for us to articulate those costs for ourselves, but the benefits, at least where I am right now in the discussion, I'm more leaning towards the benefits of creating this new term that Michael created is helpful.
It's two new terms, really. Frontline is not used in the APA anymore either.
Oh, yeah, no, frontline, oh, and primary, right? Yeah.
Right.
Correct, both of those. But I think, again, per your point, I think if we're trying to explain to agencies why they don't call it A, B, and C, we know that, why they should see some utility in that and get some new language. So, I mean, that's why I am so far in the discussion.
But
So.
Ken, your point was that calling it a decision, besides maybe not being descriptively accurate, actually carries legal consequences that we may not want to, I don't know, get at here, right?
Yes, both that it's a decision or that it would be the primary one. I mean,
Right.
even if you deemed a recommended decision, it wouldn't be the primary one because it'd be the one coming from that next sentence, from the level of review within the agency that's entering in the order.
Right. So the concern is that using the term decision, primary decision, I don't know, adding kindling to an already raging fire, perhaps.
Yes, I mean, I think, it's a high point of kind of like where everybody is on this. I think I'm closer to where I understood you to be, Jeremy, that it's not clear to me why we need the term at least in the sentence with types A and B. I can see creating it for type C. That doesn't bother me. And it seems like we use it in the context of type C. I don't know why we have to be able to use it in type A and B in order to make the point for type C.
But doesn't this turn on what the footnote says? I mean, if we can draft a footnote that explains it properly, then that should be okay.
I had a suggestion on language possibly. It is entitled, this is 34. It is entitled to an evidentiary hearing before a neutral decision maker who issues a decision that can be reviewed within the agency.
Well, it's kind of, that's in the, just further down in 36 or 37.
Yeah, well, then you would take all that out. By contrast, I don't know if we would, I mean, again, now we're debating the primary decision terminology. But I'll just say, personally, spilling a lot of ink on type A and type B when the focus is type C starts to feel a little counterproductive to me. Jack. You're muted.
Yeah,
okay.
I know. I initially I didn't like both new terminologies, the frontline decision and the primary decision. I now think that frontline decision is very useful, but primary decision is just, I think, unnecessarily confusing and introduces something that primary has a connotation that I don't think it's very clear. So here's how I rewrote the whole paragraph. I'm giving this as throwing it out there as a suggestion to see how it hits. I'm not. So what I said was,
put it in the chat.
Should I put it in the chat? Okay. I mean, it's very similar to what we have. It's just takes out the reference to primary, and just calls that the decision or additional reconsideration or additional reconsideration. Here, I'll put it in the chat right now. I thought we weren't really supposed to put substantive stuff in the.
Oh.
Is it working? Does it work to cut and paste into the chat?
That's mostly for transparency. If you just read it as you put it in the chat, I think you're fine.
I'm not getting it to. Oh, here we go. It's not doing it. I don't know why it's not doing it. It's not working.
Read it and then just send it in an email to.
So yeah, let me
So that.
see if I can try one more
I'll
time.
have it.
I
Someone
can't
can-
get it to, I can't get it to chat, so I'll send it in an email to Matthew and then he can. Anyway, so here's what I wrote. Type C adjudication differs from types A and B adjudication in fundamental ways. I guess we want type A and type B. We don't like types A and B. Type A and type B adjudication in fundamental ways. In all types of adjudication, agency staff members typically conduct an investigation of possible sanctions against a private party or determines whether.
Pass that language. Sorry.
What?
We have different language here.
A frontline decision maker, not a staff member.
Okay, yeah, well, I prefer this. Can I just finish it and then we can back it up maybe? Agency staff members typically conduct an investigation of possible sanctions against a private party or determine whether to grant an application from a private party for a benefit license permit or the like, and makes a frontline decision that the agency makes a frontline decision on whether the agency should impose a sanction or deny a benefit license or permit. In type A and type B adjudications, if the private party does not acquiesce, it is entitled to an evidentiary hearing before a neutral decision maker. Typically, the private party can also seek reconsideration of the decision of that decision within the agency, often by the agency heads. By contrast, in type C adjudication, the staff member who makes the frontline decision also conducts the initial reconsideration of that decision. Typically, the private party is entitled to seek additional reconsideration of that decision within the agency, often by a different staff member. These fundamental differences must be reflected in recommendations for best practices in type C adjudication. It just gets rid of the primary decision language. That's it. Just, I mean, if people don't like it, that's fine. It's just I just feel that the primary decision language is just unnecessarily jargony and potentially confusing.
I like it with Jeremy's change for frontline decision maker as opposed to staff member.
I'll make a pitch for the language that I proposed in 35 and deletion of the next sentence to eliminate the primary decision reference. And instead of primary decision, you could say the decision, the reviewable decision, or the decision that can be reviewed.
How would you change the remaining sentence then? Because it has primary in there.
Yeah, often also makes the decision that can be reviewed within the agency. And then in the next line of that decision without primary. Again, I'll just reiterate, I think trying to hash out what type A and B is really not the focus of this recommendation. And the more time and ink we spill on that, I think we start to trip ourselves up.
Can I request that again, let's at least accept these changes and then we can all read this as one.
There's conflict now in 29 within all and then typically. No tension there.
Could we do in all adjudication types?
How about in adjudications of all types? On 29, in adjudications
29.
of all types.
20, and
29.
yeah, we
In adjudications of all types.
Mhm.
That way it
And-
doesn't say all adjudications of all types, but
Yeah.
And then take out typically, we had put in typically, Nadine, because of you saying it doesn't, when it was saying before, you know what I mean? The agency, so I think this works. It is some frontline
You could
decision,
put often in front of a front line.
but isn't it always some frontline decision maker that is just making the decision? I mean, I don't care, you know.
Yeah,
you know-
no, I think you're right. I'm fine with that. Yeah.
Okay, so you went often in front of a frontline.
No, I think in front of a front line of
Yeah.
often a frontline decision maker conducts. Is that what you're saying?
Yeah,
Yes,
Okay, that's what. Jack.
well, that's because of Nadine's agency.
But I don't think we're pitting this on the adjudicatory agency here. It's just neutrally saying a frontline decision maker. It's not identifying that it's an adjudicatory agency who employs that decision maker. So I think it's fine with that off.
Okay.
Fine with that often, it's fine without typically.
So I think we can take out often. We're not identifying that frontline decision maker as being associated with the agency that will ultimately adjudicate.
Mhm. And put in a benefit license or something else. I mean, Jack's point on that, on 31. With the like. And then just a comma after benefit, a benefit license of the like.
Or determines whether, does it need determines in there?
Oh, yes, and I had determines at some point on 30. Right.
Private
Investigate,
party or determines.
yes, or determines whether to. Mhm.
I would like to see the word permit after license, a benefit license permit or the like. I just think because, yeah, license is different from permit, I think.
Mhm.
So I know I added within the agency, but I'm not sure there's context for that. tempted to just end with can be reviewed. Kent, do you have a reaction to that? I know you were looking at.
I like this. The only, again, I feel like I'm getting pedantic. The only thing is I would say that a license and a permit are the same thing because a license is a form of permission. So to me, it's repetitive to have both of those. But otherwise, I like this. But I do see, and I didn't want to jump to this too fast. I do see how this tees up the issue of what we're going to do with the primary decision language that's used later in the document that we identified, but presumably we're coming to that.
You can take the footnote out. 6.
Oh, I didn't see the footnote. I see.
You want to leave it in? I thought Nadine was going to take it out.
Generally, I thought we are anti-footnote, so.
So that's,
This is a preamble, a little bit looser. I
okay.
think.
Do we need to say that can be reviewed within the decision maker's agency?
You've got often twice in the next to last sentence.
Yeah, that sentence, yeah. Yeah.
I mean, so on 36, you have often, again, often by a different staff member. Is it, do you need the often there? Because
Just get rid of often and say the private party may be entitled to seek. Maybe, can you use maybe instead of often?
right, often by a different staff.
Possibly, or possibly by, instead of often, again.
Member. Possibly by.
Okay.
Mhm.
Jeff, I just read your comment, Jeff. That made me laugh. A note to self. I hear you. Any reaction to, I presume you want to take that out, Jeff?
I didn't go that far.
Okay. Preambles typically contain note to self. I don't know, a note to self. All right, any reaction to what we have? I know, Hi, would it be helpful to accept these? To read it again clean?
That's what I would say. Let's just do it one more time. We spent enough time on this.
I guess the question is if Michael can live with this.
Oh, yeah, that's, of course. But I think we're getting to, Michael,
You know, it's not my preference.
Mm,
It is, in contrast, in type C adjudication, the staff member who makes the frontline decision often also makes a decision that can be reviewed within the agency. It's kind of puzzling, I think, to a reader who's hitting this for the first time. We've all been chewing on this, so we know where we're at. But that's where the term often, that's why I like to use the term primary decision and use it for both and have a clear contrast between A and B on the one hand and C on the other. So, and I would prefer to keep that term. The staff member who makes the frontline decision often makes the primary decision in the case, having used the term primary decision for A and B. Then that primary decision is often subject to further review within the agency. To me, is going to be more understandable to somebody hitting this for the first time. It's just awfully cryptic the way you have it here. That's my opinion. But this is a stylistic question where you guys make the decision.
Well, I have Jack, Hi, and Kent speak, but I think to the extent that I made the edit there, The concern was with using primary decision to describe a type A and B adjudication. So, Jack.
So what I would say, in meeting Michael's objection, which I agree, I don't like the decision that can be reviewed language. I think that that is cryptic. I would say the following. Here's how I wrote it in the latest draft that I just sent to Matthew. Typically, the private party can also seek review of that decision within the agency, often by the agency heads. By contrast, in type C adjudication, the staff member who makes the frontline decision often also reviews that decision based on input from the affected party. Typically, the private party is entitled to seek additional review of that decision within the agency, often by a different staff member. And then I think that instead of decision that's reviewable, you say they get review. I'm just really trying to avoid it. Maybe if I'm not in the minority, I'm happy. I would still vote yes on the whole thing. I'm just really trying to avoid that primary decision language because that seems to me to be misleading.
I'll just say, Jack, since I proposed that language and you've revised, I think in a way that's much better than what I proposed. Hi.
Yeah, it is much better.
Yeah, it is much better, but Michael, I would still be interested in your thought on this. As you know, when I spoke a bit ago, I had said, you know what? We're creating two new terms, frontline decision and primary decision, but I think it probably helps for this report to sort of just give people that understanding. So I guess I don't necessarily feel strongly if this works for you and we can also have it clear throughout the recommendations, that's fine. But I guess I want to say, I just never had the same adverse sort of reaction to primary decision. And if as we go through the recommendation, the lack of having a term like that seems problematic, I just think that's something to be aware of.
Well, before you cross out Nadine's version, can we use the last part of Jack's?
Yeah, Jack's up into the version. Yeah, absolutely. No, I completely, I'll just take credit for pushing us in the direction, but Jack came up with the better language. Kent.
At the end.
Yes, about the can be reviewed within the agency. Kent.
Yeah. Thank you. I can't help, I'm starting to confuse myself with the sentence Michael was referring to, and it was going back to the language earlier, I think in yours, Nadine. But I want to make sure I'm understanding how many decisions this frontline staff decision maker is actually making. So the decision maker makes the frontline decision. Then we say, by contrast, the type C adjudication, the staff member who makes the frontline decision, so they've made the one decision, often also reviews that decision based on input from the affected party. That sounds like a second decision, but I can't tell if we're saying they're reviewing the information at the frontline stage. But continuing on, typically the private party is entitled to seek additional review of that decision, often by a different staff member, but indicating that sometimes it's the same staff member. So is the same staff member potentially making 3 different rounds of decisions, or is it 2 rounds?
No, two rounds.
Reconsideration.
The whole idea of the review is a different set of eyes.
Maybe reconsideration.
But as Kent's pointing out, the term "the decision" is thrown around all over the place. It's hard to tell. For somebody who's hitting this completely cold, I really think they'll find it confusing. And my whole purpose in drafting this was try to really make it as crystal clear as I can, simple as I could. That's why the term primary decision is helpful in contrasting A and B on the one hand, which everybody is accustomed to, and C, which nobody's accustomed to having ever thought about generically.
What if you said reconsiders on line 46 rather than reviews?
Yeah, I think reviews is better than reconsiders for the reason that Kent mentions. It's a different set of eyes.
Is there a reason we have 2 sentences there? So the staff member who makes the frontline decision, or or a different staff member may reconsider the decision based on input from the affected party. Do we need that sentence that follows?
Oh, yeah. No, it's very important to see that there are three things happening in both and all adjudication. In C adjudication, the same person makes a frontline decision, and then people can challenge it, and he then makes what I prefer to call the primary decision. Then it's easier to say the primary decision can be reviewed by a different staff member, a different set of eyes.
If that's true, again, if that's true, if you look at that typically sentence there, that suggests that the private party is entitled to seek additional review. And we've just said they may get reconsideration from the frontline decision from the agency. And that review could come from a different staff member or that same frontline decision maker. Right now, that's how that sentence reads.
Yeah, well, that's no the frontline decision maker often makes the primary decision, and then a different staff member can review that. That's that we have to get that fundamental idea across. If that's confusing, then the whole thing has to be redone.
Can we go back up to the clean version and pull in the language that Jack proposed about changing the decision that can be reviewed by the agency?
I'm sorry, I'm not sure which of your original paragraph, which sentences of your original paragraph you want to replace.
So lines 34 to 35, there was concern about the makes the decision that can be reviewed within the agency.
Okay,
And
and
we
you would
want
like
to we want to use the language that Jack came up with, which is the by contrast.
I think it's a little different now.
Yeah, I do too.
I mean, you definitely in 36, the word often should be taken out. It seeks additional review by a different staff member. This has to be by somebody else.
Thank you, Michael. That was my concern. That by taking the often out, that makes sense to me now that we're talking about a separate.
Right, got it. That's right, different eyes.
So I think there's different language as well for, did you delete Jack's? No, okay. Typically the last line of Jack's needs to come up. And lines 33 to 34 get rid of that can be reviewed, that last, yeah. No.
Well, the rest that sentence issues a decision. I see that's taken out. Yeah.
Yeah,
okay.
that was the language
taken-
that I
that's
think
taken out, okay.
Jack's edits proposed to replace. My concern with line 35 is we don't have a prior mention of staff member. That was taken out.
The frontline decision.
Yeah,
Makers.
and you can take out who makes the frontline decision.
Well, I would also take out the word often. at the beginning of 36.
Can I just say just one more thing? The last two words, instead of these recommendations, should it be this recommendation?
Thanks, Matt, for keeping up with us on this. I know it's a moving target. And we only have 3 minutes left, so.
So the term primary decision further down in the recommendations has to come out.
It does,
That's no longer defined.
it does. Okay. Shall we, Matt, we don't have time, I think, to get through the rest of the preamble. Any thoughts about? I'm trying to figure out where we are and what's left.
I think the options are either a third meeting that hopefully should not take 3 hours, or a vote by email over these edits. So that seems like it could be complicated. I think many of them are stylistic, but they might be hard to untangle.
I'm also concerned about the recommendation where we've used primary decision, and we want to be sure that we can reconcile what we just did here in the preamble with those. I think there were just 2 spots. Do we have time to scroll to that quickly just so that we can see it and get it in mind?
Do you think you could use the term primary decision, but only when discussing C adjudication in the preamble, so that you then can use that term later on? Because otherwise, later on, if you just call it the decision, people don't know which of the 3 decisions you're talking about. I feel like you need primary decision. And you don't want to use it for types A and B.
Right.
But
is it,
we use it for.
I hear you, Michael. I hear you. Is it possible that just, we'd have to go back to the preamble again, which this recommendation will refer to as the primary decision.
Exactly. That'd be great.
And so that we're not setting terminology for all time, for every purpose, for every person, every agency.
That'd be fine with me.
Just our way of referring to it. Does that make sense? Matt, could you go back up to the preamble? Our favorite paragraph?
Maybe just accept the change again. So we're just looking at it clean. And yes, I would really like that, since I was back on the, let's have 2 terms.
So where would we put it is the question, and then we will. By contrast, in type C adjudication, the frontline decision maker also reconsiders that decision.
That frontline decision. Based on input from the affected party.
And then on 36, this recommendation.
So maybe the frontline decision maker also, well, I don't know.
Yeah, I think that's a good placeholder for now, and we can think about that if we want to work back in the concept. I know there was some concerns about using that terminology, but
the problem with that is that if there's no review, is there still a primary decision?
yeah, that's a good question.
Well, that's why I was going to put it on 36 after affected party, right? Well, Michael, this is a question for you. If there's that frontline decision, if there's input
and issues. Yep. Matt, you're right on it. My brain to your fingers.
Yes. typically
Yeah, great.
of that decision.
And it's just a question of whether what could be termed or what this recommendation will refer to as.
Yes, exactly.
And that way we're not telling people that this is terminology.
And then in the next sentence, to the private parties entitled to seek additional review of the primary decision.
Yeah, and then we have the primary later. Okay, all right, it is 4:01, so I don't want to keep you past, and we have plenty more to consider. The question would just be whether we think we need a third meeting, which I think could be short, to discuss. I think there's more here than maybe could be handled voting by.
Maybe the staff could just accept the changes that they think are worth accepting and then produce a version that's clear for the remaining, and we could look at it that way.
I'm fine with that.
I mean,
How about I'll propose setting up a meeting for 1 week from today at the same time. There's an opening in our other committee meeting for that slot. I will clean everything up and committee on style areas where we had minor disputes and send it around to everyone. And if Nadine thinks we can vote on it by email, she will call it that way. And if she thinks we need to meet to discuss, we will maintain the 1 o'clock meeting a week from today.
That sounds like a plan. I like it.
I'll have to do it by email then. But
Yeah, I have no idea.
You can always send us your comments.
I will.
And of course,
I just can't meet on Wednesdays at 1. So
anything else, Matt? I was going to mention the plenary, but we're not there yet. I'll mention it next week or in an email.
Exactly.
This will be at the plenary. We will get this done.
are these meetings on YouTube, by the way? They are. Okay.
They are, yeah.
Good. Thanks.
Good.
Anything else before we close? I thank you so much for your close attention to this. This is really, I feel like we made some really good progress. And I appreciate the dialogue.
Great, thank you.
Thank you.
Thank you, everyone.
Well, thanks, everybody. Thank you, Nadine.
Thank you.
Bye.
See you next time.